I've actually done a number of probates because the decedent tried to transfer the property themselves, turned out to be an invalid deed, and then beneficiary, in this case usually children, come to me after mom or dad is gone. It's like, hey, they transferred this to me, but the clerk's saying it's an invalid deed and the property didn't transfer. And usually there's some type of technicality that was not followed in the deed. And guess what? Mom or dad can't sign a new deed from the grave. So guess what has to happen? It has to go through probate.
You got to go
And
through
then you
probate.
get into the issue where mom or dad wanted to leave it to a specific person or people. Well, they didn't have a will, so guess what? Now it has to follow the intestacy laws. And maybe that estranged child that you never had a relationship with or have been out of the picture for 20 years, now they're entitled to a portion of the real estate.
Okay, let's go.
Hi, everyone. Welcome back. Thank you so much for joining us today. As always, my name is Daniel Abreu, and I'm the team leader and founder of the Abreu Group out of Realty One Group MVP. And today we're going to be discussing a topic that affects a lot more people than they realize, which is probate and what happens when someone passes away and how it affects your real estate transactions. When someone passes away and they own a property, families sometimes they get talking as to what they need to do and what can they do. Can we sell the property? How long is it going to take? And what mistakes could happen along the way? And to help answer a lot of those questions today, we're joined by Matt Rentz of Have Bar License Will Travel. Matt, you're a Florida licensed attorney and a real estate broker who specializes in estate planning, probate law, and how those legal processes affect real estate transactions here in Florida. Thank you so much for joining, and welcome on.
Thanks for having me, Daniel. Looking forward to it.
Awesome. I want to get started and just kind of dive right into some basics real quick. Matt, you kind of went a different direction than most attorneys do fresh out of law school. You went and hung up your own shingle. Tell us a little bit about that and what kind of drew you to probate and estate planning.
So Daniel, the way I got here is when I first started law school, I was jaded real quick by the practice of law and how attorneys practice. And I was like, that is not me. I cannot do it. I didn't want to do anything by the time, billable hour. I didn't like it. It felt grimy. And I kind of got the belief that maybe it was a little easy to kind of milk clocks and milk clients, and I didn't want to litigate because you have to do billable hours if you're going to litigate. So I said, well, what can I do that I can set my fees, and like this is what it's going to be no matter what. So obviously estate planning and probate fall right into that. It's a predetermined fee usually, and it's really easy to follow it. You really know how much work you're getting into ahead of time. Now obviously some probate matters can draw out depending on claims that come forward, or let's say interested parties that aren't too amicable. But for the most part, I can control what it's going to cost and also really deliver good service to my clients and let them know what to expect. Hey, this is going to take this long. It's going to cost this much.
Having been a law student myself and working in the legal field, I can understand becoming jaded rather quickly. I get back in the days when I was at the title company, I was doing my closings. I'd often get asked by the buyers or the sellers like, "Oh my God, you went to law school. What are you doing here?" And I always tell them the same thing. When I was working in the legal field, when I was sitting at a table with clients like this, oftentimes it was because they were coming to see us on the worst day of their lives. Today, when I'm sitting at a table with clients, it's because they're either selling a house and getting a check, which usually puts a smile on their face, or they're buying their dream home. And again, they're sitting there with a smile on their face. So yeah, that was the aspect that that jaded me, just continuously having those conversations with people. where they just, it was always a bad day. There was never good news when we were talking to them. So let's kind of just dive right into it. Let's start at the beginning of the probate process. And for those who are unfamiliar, what exactly is probate and when does it actually become part of the entire real estate process here in Florida?
Okay, Daniel, before we get started, I'd just like to say this is for general informational purposes only, educational purely. I'm not providing any legal advice. If anyone has any questions, they need to reach out to a qualified and licensed Florida attorney in their area of need. But to answer your question, probate is simply the process of changing title from a decedent's name to either the beneficiaries in a will or heirs at law, and that's only for probate assets. And I think that's really where people get confused about when something needs to go to probate, and it really comes down to whether or not it's a probate asset or a non-probate asset.
So that kind of leads me into my next question. What determines whether or not it's a probate asset, and what determines whether or not a property must go through probate or if it can transfer outside of the probate process?
That's a phenomenal question, and it is a kind of a long answer. So I'm going to do as best I can to abbreviate it. The simplest way to put it is a probate asset must go to probate, and a probate asset is an asset that does not pass via operational law. I know those are very legalese answers, so I like to give an example. Let's take your checking account. Your checking account has no beneficiary on there. When you pass away, that must go to probate to determine where it goes, even if you have a will. This is something I want to touch on here in a second, but sticking with that checking account, let's say you put a beneficiary designation on there. You pass away, the beneficiary survives you. Beneficiary takes the death certificate, your death certificate, to that financial institution, proves who they are, and financial institution pays out, or that asset, that checking account, passes via operational law. So that's really what it comes down to: is the asset going to pass via operational law after you pass away? And most people are like, well, yeah, duh, it's going to go through me through probate. Isn't that operational law? It's like, well, not really, because financial institutions, when it comes to checking accounts or any type of investment account, monetary account that has a beneficiary on there, they can pay that out outside of probate because it's contract law. So I'm saying to them, hey, look, this is mine. I want you to give it to these people when I'm gone, and I go through their process to designate that beneficiary. Same with like life insurance proceeds. They all pass outside of probate if there's a beneficiary designated. So those are all non-probate assets. But if you take those same assets, remove the beneficiary, or the beneficiary doesn't survive, most of the time that's going to become a probate asset.
And when the real estate actually becomes the probate asset, which is typically right because it's such a high dollar amount, um, why is that often one of the more complicated facets when you're dealing with an estate?
Well, there's quite a bit that goes into that. So the first thing, you can turn real estate into a non-probate asset, and the two most common ways would be you title it into a trust. So you create either a revocable or irrevocable trust, and the trust owns the property. When you pass away, the trust still survives. The trust manages the real estate in accordance with your wishes in the trust agreement. Another way is what's commonly known as a ladybird deed. The legal term for it is enhanced life estate. That's essentially designating a beneficiary on real estate. Hey, look, if I still own this property when I pass away, I want it to go to this person or these people. They have no interest in it unless and until you pass away still owning that property. So that's ways you can get it to avoid going in probate. But moving on to your question about why is it difficult to deal with real estate in Florida probate, is homestead. You know, we're blessed to live here in Florida. We have a wonderful homestead. I would say I'm not licensed in any other states, but I'm pretty sure that Florida has the best homestead protections in the country. And you know, a lot of people think, well, that homestead is just my tax discounts that I get every single year. But there are also constitutional protections that come in there from alienation, right? So no creditor can file against your homestead. Likewise, you can only bequeath your homestead property to certain parties, typically your spouse, children, and they're protected underneath the homestead too. So whenever you pass away, you own real estate. First question is if it's homestead or not. And then that's where we get into the difficulty with probate and dealing with real estate in Florida.
So I want to get a little off topic because you brought up ladybird deeds. And this is just something that came to mind real quick. And this is going to be more for, well, it's going to be for everybody, but give, give your opinion on this. This is something that just happened to come up on the Facebook group for my brokerage, right? Somebody in the group, and it's only the realtors that are associated with my office, but somebody in the group asked about ladybird deeds. Um, and a lot of realtors, myself included, all recommended go speak to an attorney.
Great answer.
They'll get it done. Um, but somebody in the group said, "I have a blank form that I can send you and you can help your client fill it out." Do you have any opinions on that? Because I certainly did.
Yeah, that would be the unauthorized practice of law. Undoubtedly, they're going to be providing legal advice, and in Florida, you are not allowed to do so unless you are a licensed Florida attorney. So that's it in a nutshell.
And that's my advice for realtors. Do not try to do that you're on your own. And sellers or homeowners, please, for the love of God, if you are thinking about transferring your property, even if it's just for family planning purposes or estate planning purposes, whatever it would be, talk to a licensed professional about it. Go speak to an attorney, spend a little bit of money, get the investment, because my God, it will protect you in so many ways. Thank you for that opinion.
Yeah, I want to add to that, Daniel, because I've actually done a number of probates because the decedent tried to transfer the property themselves, turned out to be an invalid deed, and then beneficiary, in this case usually children, come to me after mom or dad is gone. And it's like, hey, this they transferred this to me, but the clerk's saying it's an invalid deed and the property didn't transfer. And usually there's some type of technicality that was not followed in the deed. And guess what? Mom or dad can't sign a new deed from the grave. So guess what has to happen? It has to go through
You
probate.
got to go
And
through
then
a
you get
probate.
into the issue where mom or dad wanted to leave it to a specific person or people. Well, they didn't have a will, so guess what? Now it has to follow the intestacy laws. And maybe that estranged child that you never had a relationship with or been out of the picture for 20 years, now they're entitled to a portion of the real estate.
Yeah, it's I can't tell you from the days like when I was back at the title company and actually doing processing and closing and all that. I can't tell you how many times I would have to call up an attorney or somebody because something went wrong on, and people, they tried the DIY method and it backfired on them horribly. Kind of getting back on track to the basics of probate and real estate transactions and everything. At what point, in your opinion, should a realtor get involved in the process? At what point would you want to bring somebody in if you're working with a client to help them either sell the property or do something with it?
That really depends on the client goal. Obviously, if the all the heirs at law or the beneficiaries in the will, if they want to sell the property, obviously depending on if it's homestead or not, because if it's homestead, homestead is not counted against your probate estate for estate valuation when it comes to probate in Florida. And the other thing is once you do the petition to determine homestead status of real property, and once you get the order from that, that homestead property comes out of the estate. So it's no longer part of the estate. Now, if we're sticking with a piece of real property that is not homestead or is staying in the probate estate, well, what's the goal? Do we want to sell it? Because if we want to sell it, we need to get a realtor involved. And then we need to go through the process, let the realtor know, hey, look, we have to go through this because it is a probate asset. We have to petition the court to sell the real property. Then we have to get an order from the court to sell the real property. So it might kind of break your process up a little bit. You might have to wait longer than you would like, or you might have to go through some hoops that you're typically as a realtor don't have to go through in a regular transaction.
And that kind of brings me to my next point, right? You mentioned the heirs and everything. let's talk a little bit about authority, because this is where a lot of the families will oftentimes get confused. When someone passes away and they own a home, who actually has the legal authority to sell it if that's the ultimate goal?
Well, there's two answers to that. One would be the court-appointed personal representative who is awarded letters of administration, or when it comes to the property coming out of the estate, then it's whoever's on title. So let's say it's homestead property and there are three living children. All three children will be on the property. It's no longer part of probate, and then the three children would have to come together to determine, okay, do we want to sell this? Do we agree to this offer? Do we agree to this transaction? Now, sticking with the personal representative who's appointed by the court and has letters of administration, LOAs, are typically like a license to manage the estate. So then that person would have the authority to, one, enter into real estate contracts for sale, and then two, actually sell everything at the closing table.
And when there's no personal representative, right? And the heirs have to come together. So your example, you've got three kids, they all have to come together. Everybody needs to sign the listing agreement. Everybody needs to sign the purchase and sale agreement. Everybody needs to sign the closing docs, correct?
Correct.
And when it's the personal representative, that is the sole person that would be the one doing it. So what role, I mean, we kind of just talked about it, but what role really does the personal representative play throughout this entire process? Are they the main contact for everything?
For the most part, they really are. I like to kind of set my personal representatives up whenever we're doing a probate estate and they're my client, or if it's multiple PRs working together, just let them know, it's like, hey, look, I'm going to be the coach. I'm going to tell you exactly what we need to do. You're the quarterback. You're the one with the license. You're the one that's actually been on the field doing most of the work, administering the estate. I'm the one that'll do everything with the court and let you know what you need to do on the field.
And when there's no personal representative and the heirs need to come together, what happens typically if the heirs disagree on what to do?
I've seen a lot, but typically you have one, they'll just kind of let it sit and won't do anything with it, or two, they'll actually file a partition action. And the partition action in Florida is like, hey, look, we're co-owners of this property. We can't agree on what to do with it. I want to sell it. You don't want to sell it. You know what? Let's put it before a judge and let the judge decide.
Yeah, and unfortunately, I've seen that more often than not. Won't go into specifics, obviously, but Maria is a personal injury attorney, but she also volunteers some time with legal aid. And I've seen that they've been kind of jumping through some hoops with a client that they've been helping on a similar thing. And the only course of action that they really have left now, because of the circumstances and the way that it's come, has been a partition. It's a real sad case. But unfortunately, it's the only way that they're going to be able to resolve it.
It's sad.
So once the estate is opened and authority is established and everything, what does the sale process actually look like? So can the property be listed and sold before the probate is even completed?
If it's probate asset, it cannot. Well, I'm sorry, before it's completed, yes. Sorry. I apologize. I misunderstood the question there for a second. If once the probate process is
You're
opened,
fine.
yeah, there's steps to sell real estate that is part of the probate estate. That really you can't. We've had clients that will enter into listing agreements that are PRs before they actually get letters of administration to kind of get the show started. But no one has the authority to bind the estate until they have letters of administration from the court. So I have a PR, they sign a listing agreement, and like a contract, they want to enter into a contract, but we haven't got the letters of administration yet. Typically, no one can hold them liable. So the realtor can't say you signed this listing agreement on behalf of the estate, and anyone they entered into, let's say they're trying to sell property, buyers can't hold them to a contract they signed before they have letters of administration. So you kind of really have to wait till you get those letters of administration to do most of the work. And then continue with the process. Let's say they have an offer they like, they enter into a contract for sale of the property, and they already have letters of administration, well, then it just comes down to, okay, what's the actual sale process? And that's where you be controlling it. Have we gone through the inspection period? Have we gotten the approval if there's getting a loan? All the sale requirements. And then the only other thing that we need through the court is the order to sell. So we do the petition to sell, we include all the documents for the sale agreement, and then we have the order to sell. And that only comes from the judge after he reviews everything. Once you get that order to sell, the ball's back in the realtor and the seller's court and buyer. So, okay, can we move forward with our ready to close?
And that kind of brings me to my next question, right? Like, so how does the timeline differ on a property that's got to go through the probate process versus a traditional home sale? So, for example, like a traditional home sale, we get a contract signed, everything looks good. We're typically looking at 20 to 45 days to close. Does that differ on a probate estate where probate is involved?
Sometimes it does. I always like to tell my clients and realtors, hey, look, we're at the mercy of the court's docket. We can get everything submitted to the court this week. If they don't look at it for 3 weeks, depending on how busy their docket is, well, there you go. We're kind of at the whim of the court system, the judicial system, right? We can't actually sell the property until they review the petition to sell and all the supporting documents, and then order the sale and once you get that, then it's back to, okay, where are we at in the sale process? Are we good to clear? Are we clear to close?
And aside from getting the authorization from the court, is there anything else that we really need to be able to move forward with the sale?
One thing I would say, and this is really just a practice point, and this is what I tell all my realtors whenever we're going through probate where there's an actual piece of real estate that needs to be sold in the probate process, is to don't set firm close dates. Instead, say on or before March 31st. So that way, if we get an order to sell and it's anytime before March 31st, hey, look, you got the license, give it to the title company or whoever's doing the closing, and you'll be able to sell as soon as everything else is met on their side. Because if you do a firm date, well, now it has to be that date. And if we need anything changed, we don't want to go back to the court to have anything amended. We would much rather make it where the court reviews the petition, gives us an order, and it's very flexible. Because if it's rigid and we need it changed, guess what? We have to go back to the court through the process.
So, do you typically recommend to your realtors to maybe do a longer escrow period? Like instead of that 30 days, maybe give it 60?
Yeah. I typically tell them, hey, look, let's do it a 60 to 90 days and we'll just put on or before. So guess what? We get a great docket. It gets through in 22 days. There you go. You're good to sell. Or if we get an issue where it doesn't close in the 30 days or 60 days, guess what? We still have it where it's on or before. And that really comes down to the document itself, right? If you enter a sale agreement and it says we're going to close by February 31st, and you don't close by February 31st, but everyone wants to stay in the transaction, they do an addendum, guess what we have to do?
Now
We
you've
have
got
to
to
give
go
all
through
that back to the
amendments to
court.
it. Yeah.
Exactly. Anytime it changes, we got to let the court know.
Are there any other things in the probate process that could delay the sale?
I've been very fortunate that anytime I've had to sell real estate in the probate process, it's been pretty simple and easy in the sense we know what we need to do. I would say it really just comes down to the biggest troubles I've had have been the market. So, for an example, and to start 2024, I had a very nice condo in Ave Maria, and the personal representative had it on the market for 9 months, and it was priced great. But guess what? We got an offer, it fell through. We got an offer, it fell through. We got an offer, it finally stuck and sold. Thank the Lord. But that's really the only other thing outside of the probate process. Now, of course, you could have creditors come forward because if it is part of the probate estate, it's open and liable to creditors. You could have, let's say, difficult heirs or beneficiaries dealing with the probate process. There's just things that could happen in the probate process.
And let me ask, a lot of many probate sellers, they've never actually lived in the home, which always makes condition kind of a big question. Um, do you find that probate homes are typically just sold as is?
Absolutely.
What does that usually mean legally for them when they're selling as is?
I love that. You know what my answer is? As is. Take it or leave it. This is what it is.
Exactly. I mean, I have that argument often with sellers, and then inspection periods come up, and then requests come up, and I'm like, hey, look, it was an as is. We're sold it. We offered it as is. They wrote on the as is agreement. You have the right to just say no to all this stuff. It's up to you. But I find that a lot of sellers now are more willing to negotiate. Um, Are there any disclosure requirements or anything that apply for sellers right now uh, who have never occupied the properties, especially in cases like this?
That'd be a great question, and I would defer to you actually practicing on a real estate side. Is there anything you can think of as like, hey, because you don't live here, because you've never lived here, you need to sign this disclosure?
I give everybody the seller's disclosure, even if they've never lived in the home. I've had investors tell me, I don't have to sign this. I've never lived there. I said, yeah, but you're an investor, which means you bought it. You've done work in it. You know the work that you've done. Let's at least answer those questions. And anything that you don't know, you're allowed to put, I don't know. But at least you're covering your basis by just putting in the stuff that you know that you did. Should probate sellers make any kind of repairs before listing or sell a property or just sell the property in its current condition? And I'm asking you that question specifically because you deal with it so often. You see how long properties sit. What would be your best advice in those circumstances?
It's always going to be it depends. What type of condition is the property in, right? And do you want to sell it as is and maybe limit your potential market, or do you want to add a little bit to it to try to increase its sale price and also desirability? Because as I said, that place down in Abreu, that was a great place. It just happened to be in a horrible time in the market, and then all the builders around there were offering huge incentives for people to buy a new house. So now you have a brand new house that no one's ever lived in, or a house that a deceased person resided in. And which one do you want? Because this one you get a golf membership. This one you get all types of incentives at the closing table from the builder. So it really comes down to depending on the market, where you're at, and how quickly you want to sell.
Yeah, I always tell clients the same thing. When I'm sitting down at the table with them and they ask me those kind of questions, I say, "Well, I'm going to give you the lawyer answer. It depends. Here are your options." So let's kind of move into some of the legal and financial pitfalls that could be involved for probate sellers. What are the biggest legal mistakes that you see sellers making when probate is involved in the real estate process?
Um, I think it would really come down to just a lack of education and understanding on how probate works. Because a lot of times we have people, someone passed away, and then the child, without opening probate, is trying to serve as a personal representative without doing anything through the court. Basically, they say, I'm the one that's entitled to it, I'm the only child. Mom or dad didn't have a will, I know it goes to me. While all that is true, you don't actually get anything until the probate process is started. So I have had a couple of states that come to me and they already have buyers and everyone at the table, and they have already been to the closing table to the title company. The title company says, we can't do anything until you open and administer probate. I would really say that would probably be the biggest legal issue that I see with sellers trying to sell property is they don't try to follow the process. And I think a lot of it comes from just a lack of understanding or knowledge about the process. A lot of times, like Title company says I need a closing order of summary administration or something along those lines, and that's how they end up in my office.
Yeah, I can't, again, back in the days of the title company, I can't tell you how many times it would come up on the title commitment, you know, seller doesn't have the authority to do this because it still needs to go through the probate process, or they need to provide some documentation showing that this was the intent. And many times I've had to defer to or back then I had to defer to real estate or probate attorneys, because it just we needed to stop everything where it was, and then buyers get disappointed and timelines get screwed up, and it can be a real disaster when people don't follow the process. um that's why I thank God I have my experience from the title company and the education that I have. I will do a quick I run my own title before I even meet with a seller, because I can sit down, I'll look and say, okay, this is your name and this is how you're signing, but this is not the person who actually is on the deed currently. Who is this and how do we have that authority? So it always, one of my sellers right now, when we signed the listing agreement, she's like, hey, I really don't want to sign my full name and you put it into the e-sign. I said, that's the way that it appears on title. That's the way we're going to sign it. If anything else has changed, we're going to have to go through a totally different process and get attorneys involved. And she's like, no, it's fine, everything is the same. I'm like, okay, good. um can a sale fall apart late in the process because of any probate related issues?
Um, Huge. It depends, right? Again, creditors, other interested parties, non-informed parties. I mean, all of them could be lying in the weeds, and they could come forward and kill the sale.
And that's why it's important to have a strong team, like a realtor who knows what they're doing, an attorney who is specializes in these kind of matters specifically. I mean, having the right people around you is going to make all the difference and going to make it a smoother process. Um, why is it so important for probate sellers to work with both a probate attorney and a realtor who specializes in these kind of cases? Um, for that, I mean, aside from anything like just making it an overall smoother process, why is it so important that they have that team around them?
Really just helps, like you said, smooth everything over. An experienced realtor like yourself, an experienced probate attorney like myself, we know the process. We know what we need to do ahead of time. And, we see probate matters start where maybe they don't really understand the process, and every step becomes a hurdle. Oh man, we didn't foresee this. Now we have to deal with this. Then something else comes forward. Oh, we didn't see this. Now we have to deal with this. If you have the experience of going through these process, you know ahead of time what to look for. Like you just mentioned with the title, if they're not on the title to the deed, there's no point in even moving forward until we discuss, okay, how is title? Why is this name on title, not your name? Same thing when it comes to selling real estate through the probate process. You put on that closing date on or before February 31st, and you don't make it by then, guess what? Now we have to go back, and that might delay the process 2 to 4 weeks. You never know. And then the buyer might say, you know what, I'm not really interested in waiting another 4 weeks. I can do two if you can guarantee two. I can't guarantee two because it's got to go to the court.
Have um have you ever, in your experience, when you're working with realtors, and I'm going to ask this because I've seen it often, both on the legal side and the realtor side, through work experience. I've seen it often where realtors can get sometimes a little combative with the attorneys because they don't understand the process and they're frustrated because things aren't moving forward. Have you experienced that?
I wouldn't say necessarily combative, but not having understanding on the process, even though we discussed it ahead of time, can kind of drain on that relationship a little bit. And I would like to use an example. I have a personal representative who has submitted all the petitions here in Florida, but Florida is the ancillary state. The decedent passed away in New York. They were domiciled in New York. So New York has its own probate proceedings. Florida's ancillary, which is essentially just saying non-home state proceedings, there's real property here in Florida. So we're kind of sitting on go, waiting for everything in New York to get where it needs to be. Once she gets the letters of administration and everything, now she has the authority to do it all in Florida. Then we get everything approved here in Florida, and then we can submit the petition to sell. Then we can wait and get an order to sell, and then basically everything goes back up the chain to New York. And it's just, it doesn't happen as quickly as people want. And we can be sitting on go waiting, but until we get the documents that we need from the domiciliary state, and this example is New York, we can't do anything, and there's nothing that I can do about it. I can call the New York attorney every day, but he's not. Same thing. He can't just call the New York clerks and be like, "Hey, we need this today."
So basically, at the mercy of the court, no matter what. Um,
It's nice to have a relationship with the clerks. It's nice to have a relationship with the JAs, but at the same time, that's not going to solve every problem. Sometimes you're just going to have to wait your turn.
um, do you find that early coordination between you and the realtors that you work with, do you find that helps prevent any of the delays or anything in the process?
I don't know if it really helps prevent the delays in total, but at least it puts them on the radar and we can start saying, hey, these are the things that we're going to need at this time. And this is basically the steps that you have to take in order to get there. We can't just jump right to the end. We need A, B, and C before we can do D. So I think it does help as long as the realtor or the personal representative, right? As long as they're willing to do the work. Remember, I tell them all, look, I'm the coach. I'm here. I'll deal with the GM who's the judge, but you're on the field. You got to make the work happen. I can't do it for you. I can just guide you, and I can do the stuff when it comes to dealing with the court and sometimes dealing with the parties involved. But for the most part, I'm not the one with the letters of administration, right? I can't go to the banks. I can't go to the title company. I can communicate with them, but you're the one with the authority to do it.
What information do you think sellers should have before speaking with a realtor about listing a probate property?
You're going to want all the information on the estate, right? Just so you get an idea of where the estate's going to need to be administered. So if I'm a realtor and I have someone coming to me wanting to sell mom or dad's property, you already nailed the first one. Okay, who's on title, right? All right, now we know we can figure out whose estate we need to probate. Were they domiciled in Florida? Did they live in the county where they own the property, or do we have to open up probate in another area? Because if they live in Florida, you have to open probate wherever they live, not where the property is. They might have property in 5 different counties, but you have to open it in Lee County because that's where they resided. Same thing, if they live in New York or West Virginia or Michigan, you have to open domiciliary estate in the home state and then use it to begin the process here in Florida typically. So I'm going to want to know those as a realtor just to get an idea of, okay, who's on title, they're gone, where'd they live? And then that really gets you, okay, we're gonna have to worry about dealing probate in here or there or in both places.
So always good to ask the heirs when I'm sitting down with them, and it's a question I typically ask, but same thing, right? Like, so I've run title. I know if somebody is living in New York and I'm sitting with the heir or I'm talking to them on a Zoom call like this and just kind of going over the listing process. First thing I ask, so have you started the proceedings in New York, if that's the place? And if so, when do you plan on doing that? Because we need to wait until that's taken care of before we can do anything here. Um, Kind of flip perspectives for a minute and let's talk about buyers and investors because we know investors love the probate properties, right? I'm an investor myself. I go after them all the time. Is there anything that buyers or investors should know before pursuing a probate property?
Really, just everything we've discussed. That it is a process that has the court oversight, so they're going to watch the whole process from start to finish before you can actually buy the property. And one of the things is when it comes to sale price, a lot of times we might see below fair market value offer, and seller doesn't live there, has no inclination, and just sees, oh, I'm going to get X amount of money. Sure. Well, guess what? The court has to approve the sale price, and they're going to want some input from the personal representative as to why they think that's a fair value, fair sale price, sorry, for the property, and that comes down to the court, right? The court's going to ask that.
So typically, when I'm talking to a seller and I'm talking to them for the purposes of actually buying the property and investing in it rather than as a realtor and trying to list it, right? Usually I have that conversation with them and I just explain it to them and I tell them, and all my agreement has the disclosure I'm a realtor and everything, but I also make sure they understand I am buying below fair market value. The purpose of buying this is as an investment. Is that something typically that you see, or is it sufficient for the court as long as they sign and understand that they're selling the property below fair market value?
I really think that's going to come down to the court, right? They're going to have to review that. And it also depends on the situation, right? Is it a bad market? Would it sit on the market for 9 months? Would the seller, personal representative, have to pay a mortgage for X amount of months before it sells? Like, there are a lot of things that can go in there. And basically, I would say make your case, right? Have the personal representative make the case why they believe it's a fair price, why they're doing it. And that's perfectly fine. And it just comes down to judge's discretion.
And I've provided sellers with exactly what a rehab would look like and what the current condition is. I even have gone as far sometimes, usually when I'm on those calls, right? It's because they've contacted me as a realtor. And then, I shift gears a little bit and I tell them, hey, look, rather than listing the property as is and letting it sit for 9 months because of the current condition and the current market, um, I can give you an all cash offer on it right now, or one of my investors can give you an all cash offer on it right now. And we can work something out, but understand that it's going to be based on X, Y, and Z, right? Like the rehab is going to cost $150,000. We've got to do, all of this work. And usually the sellers, I can't say all the time, but usually they're pretty understanding, right? Like they see the property, they know the current condition that it's in, they know that it needs a new roof, it needs HVAC, it needs new floors. Like it doesn't look anywhere near what comparable properties are. So usually they're pretty understanding about it. Thankfully, in my experience, I've never gotten a lot of pushback from the courts other than, you know, kind of give me a breakdown of what it is that you're thinking about doing. And then we've always gone through the process of explaining what the rehab is, and that usually has been sufficient. Um, are there any contingencies or anything that you think that buyers or investors should be aware of when buying a probate, aside from obviously we know longer timelines and stuff like that?
I don't know if I'd call it a contingency, but it's definitely something that your personal representative or seller or estate is going to want to be aware of. Is if probate property has a mortgage, decedent passed away, guess what? That mortgage doesn't just disappear.
Yep.
That mortgage
Still
is
got to
still
be
there.
paid.
Exactly. If you don't pay that mortgage, they can come out and foreclose on the property, even though the owner is deceased. It does not matter. And I've seen probates where, like that one in Abreu, there was a mortgage, and thank the Lord that there was actually liquid assets in the estate to carry the mortgage until it sold. But I've seen probates where there is no assets, liquid assets, where the asset is the property and the property does have a mortgage on it. Well, guess what? If someone doesn't pay that, it's going to be foreclosed. So then you start getting into, well, who's going to pay it? And are they going to be recouped at the closing table? Are we going to sell it and make it where, look, we'll recoup you at the closing table? Because that's a thing that most people, I don't think they really think about whenever someone passes away, is there's a mortgage and it still has to be paid. Just like taxes. Uncle Sam wants his money.
Yeah, and don't forget the real estate taxes. You got to make room for that, right? I mean, you can might be able to bypass it for a little while, but eventually they come knocking at the door, and Like you said, Uncle Sam wants his money. Everybody wants to get paid. Before we wrap it up, I know anybody watching or listening, they probably are feeling a little overwhelmed because we've really covered a lot. If somebody has just inherited a property and they don't know where to start, what do you think is the first step they should be taking?
If they just inherited property, I would say, what's the goal, right? Do they want to keep it or do they want to sell it? If they want to sell it, they're most likely going to want to reach out to a realtor, experienced realtor in their area or in the area of the property. Hey, I want to sell this. What's the process look like? If they just inherited the property but it hasn't been probated yet, all right, well, you're going to want to contact the probate attorney that's in that area that has experience. So you kind of put your horse in front of the cart, right? Make sure we're going to go through a smooth process. There is a lot to be dealt with, but like I tell my clients all the time, it just sounds complicated because you don't live it. This isn't your job. This is my job. It's not very complicated, and we know what we're doing because this is what we do every day.
Is there anything that you would say to families who are worried that they're going to make some kind of mistake in this whole process?
Hmm. Kind of seems like a very broad question, right? What are we talking about? Pre-death or probate properties in probate?
Let's cover the properties in probate.
Okay. So properties in probate, make sure you have a good team because they're going to help you get through everything. And the good team is worth it because otherwise, if you don't have everything in place or if you don't follow the process, guess what? Time is money. And if your process gets delayed a couple months, that buyer that you had interested might not be interested anymore. Now you just lost the sale. You got to go through getting another one. So it's like I say, it's better to put your horse in front of the cart and make sure everything goes nice and smooth.
How early on in the process would you recommend to families that they actually reach out to a probate attorney?
Soon as someone passes away, right? Just because you don't know what to do doesn't mean the process gets delayed or stalled until you step onto the field. Soon as owner passes away, it's probate. Whether you start it today or start it in a few years, whether there's a mortgage, no mortgage, the time isn't waiting on you. It's everything's already started as soon as they pass away.
Yeah. Matt, this has been incredibly helpful. Thank you so much for doing this. Probate isn't just a real estate transaction, or it's not just part of the real estate transaction. It's a full blown legal process, and having the right guidance and everything is so important, and it makes all the difference. Um, how can people reach out to you if they have questions or if they're in a similar situation to anything that we've discussed?
We have a phone number, 844-464-2598. And really go onto the website, which is just an acronym for the firm name. So it's HBLWT. Go on the service. You can get your consultation scheduled by the end of the day. It will not take very long.
That is
Thank you, Daniel.
amazing. Matt, again, thank you so much for doing this. And if anybody needs any kind of clarity, if you're acting as a personal representative or if you have somebody that's passed away, reach out to Matt and his team. They are phenomenal. And we look forward to seeing you on the next video. Thank you.